Hi everyone. So today is Q&A day. I did get questions ahead of time, so I will be responding to those questions. But if you are joining me live, if you're watching this on the replay and you have questions, go ahead and put them in the comments. Do go back and respond to your questions, especially when I do these Q&As. If you send me questions, I probably responded to it, or I will respond to it in a video. So feel free to ask me your questions. If you join me live, this session is literally for you to ask me questions. That's the only reason I'm here. So if there's no questions, I will over questions that other people have to, you know, help you make sure that you have the answers to these questions, because sometimes you join me live, you have questions, but you're, worried about asking your questions. I just want to let you know it's okay. That's actually what today is all about. All right. So if you're joining me and you have questions, put them in the comments, say hi, and jump right in. Like I said, I will be going over questions I received in my comments, just to basically go over those, because I've been getting a lot of questions. So I want to start with this question: why do you and or your firm take on defense cases, immigration defense cases? Is it because you are young in the profession, or so? Let me be clear. I was doing immigration defense cases. However, I just love doing family-based immigration. I love doing waivers. That is my jam. So I refer people out to other lawyers where removal defense is literally their love language. Like, they love it so much that, and they're so good at it, that it doesn't make sense for me to do something just to say that I do it. Okay. The point of me having my own firm is that I get to decide what type of cases that I do, and that I use this medium, right, doing these videos, to still give back and help as much as I can while taking on those cases that are not really things that I want to take on. Okay. I do those a lot with my volunteer work, and of course doing these videos. So it's not that, I've been an attorney for 10 years. No, 10 years doing this. So it's not like I woke, I just started being a lawyer and just don't want to do it. I've been doing it 10 years. And, as you grow in whatever profession you have, you kind of pick and choose what you want to do. And I happen to be in a position where I can pick and choose what I want to focus on. Right. So that is one. Hi, Deirdre. Hi, Deidre. Sorry. Hi, Kasmita. Good to see you. Do you remember last year I told you MVC sent saying I have to the embassy with my visa? Yes, I do remember. I do remember. Do you have questions about it? Feel free to ask me. But I do remember. I hope it went well. I hope everything has been moving the way you want it to. But if you have questions, go ahead and ask me. Okay. So I have a question from someone watching my CRBA video. Listen, if you want a specific topic, best place to do is go to my YouTube channel if you're watching on Instagram or Facebook, and search that topic, because I probably have already done a video on it. But I did a video on CRBA, and the person is asking, my spouse is short 13 days of physical presence, and my baby is just 2 months. My IR1 interview is next. What do I do? I'm confused. So if you have a child that was born outside of the US, you've been a US citizen, you were a US citizen before the child was born, you have 5 years of physical presence in the US, that child is automatically a US citizen. but you have to do a CRBA, consular report of birth abroad, to basically not only get them out equivalent of a US birth certificate, but to also get them their US passport. If you do not go through this process, the child will not have any proof that they are a US citizen, even though by law they are a US citizen. So that 5 years of physical presence is the law, right? You have to be able to show 5 years of physical presence. But if you're not able to show it, then your option literally is to file an I-130 for that child and then wait for the I-130 to be approved and then do the consular interview. So you want to make sure that the second you find out that your child that's born outside of the US does not qualify for CRBA because maybe you don't have the physical presence or you are not a US citizen before they were born, you want to go ahead and file that I-130 because those are taking time. So if the spouse that's outside of the US with the child already has a visa application pending, they're just waiting for the interview. What I would do, right? Again, not legal advice, but what I would do typically in our firm is file that I-130 as soon as possible, request an expedite of the I-130 just based on the age of the child, and the child cannot be left alone. And we've done a couple clients, and those have been approved. And then when you get to the consular processing, if the spouse has not scheduled for an interview yet, that is good. Because once they're scheduled for an interview, you can then ask the embassy schedule the child's interview at the same time because it's the same petitioner, it's the same sponsor, it's the same everything. So that way, the child and the mother can go to the interview at the same time and be approved at the same time. However, if the I-130 is approved after the mother already had their interview, already on their way to the, already got their visa, your option is to do an expedite request at that point and ask for the for the embassy to schedule the for an interview ASAP because the child is going to be left without a caregiver, which is going to cause extreme emotional hardship to the US citizen parent. So there are ways to speed things up when you're in a situation where CRBA is no longer an option just because of some timing issues. But there are steps you can take to make sure that the mother of your child and that child are still able to come at the same time or at least close enough to the same time. All right. So if you have questions, I already see your questions. Please ask me questions, okay? Hi, Johnny. Thank you for joining me and in Florida. Thank you. All right. Sure. Good morning. All right. So you had the email from the embassy and you're told to answer. Oh, and I told you you need to respond to that email from the embassy, let them know that you already received your permanent residency, so you would not be doing consular processing. Oh, so they want me, sorry guys, I don't know what just happened. They want you to send them a copy of your green card. Yeah, so that's normal. So when you, I'm trying to think of the best way to put this, but when you're telling the embassy that you already got your green card, so you don't need to do processing, you don't need an interview at the embassy, they're going to need proof. They're not just going to take your word for it. And typically when we send that message to them to say, hey, by the way, our client already got their green card, we include a copy of it because that's the only way they can confirm that you actually have already received your green card. And then the embassy can close out that case. They don't have to keep checking in with you after that. Okay. All right. All right. How with Mika asks, good morning. Hi. Is this still a good time to file adjustment of status for an overseas parent? Listen, is it a good time? It depends on you and your family and what you have decided would be the best option. Okay. There is a risk. I'm that person that will tell you there is a risk with filing any petition, especially with the environment that we're in right now. Any petition you file, if it is denied, you could end up in removal, right? I'm answering this question. So if your application is denied, there is a chance that you end up with a notice to appear, okay? However, even if your application is denied, so if you have an overstayed parent, this is very like much specific. If you have an overstayed parent, means they're undocumented. Okay. Yes, we say overstay because they didn't come in through the border and they had a visa when they came, but they are still considered undocumented. And there is a push by this administration to go after overstays. So yes, if your parent qualifies for adjustment of status, filing for adjustment of status by itself does not give them protection. Okay, I always want to make that clear. Filing for adjustment of status does not give them protection. However, once it is approved, they have their green card and they are no longer subject to deportation for being an overstay. Okay. So it's really, really important that when you're thinking about the risk and reward, that's kind of what you have to think about, right? What is the risk of them potentially being up by ICE and you not having filed anything for them? If, okay, you're saying they've been here for 30 years. If they've been here for 30 years, one thing I always recommend, actually not one thing, two things. One, get a copy of their FOIA from USCIS. So get a copy of their file from USCIS, because if they have anything in there that could potentially be an issue, you want to know about it before you file anything. And typically when people have been here for 30 years, 20 years, they may have filed something in the past and just forgot about it. So I always recommend getting that for request from USCIS. And then secondly, getting an FBI background check. Okay. Sometimes people forget that they were stopped, by the police or anything like that. So you want to get the FBI background check and you want to get the FOIA request just to make sure that the 30 years you've been here and everything looks good. And if everything looks good, then it's just a matter of the risk reward of should I, right? Should I go ahead and file now or later? Understand the more you wait, the more, the longer it's going to take for you to actually get what you ultimately want, which is for your parent to have that permanent residency. Okay. All right. Had to shift my stuff because my mouse decided to stop working. All right. If my daughter wants to petition for me, she's 21 and a citizen, and I had her with emergency Medicare. Should I need to pay for it before filing, or not at all, or when or how? Okay. So emergency Medicaid is not a bar to adjustment of status. Okay. If you get regular Medicaid, that's a problem. But emergency Medicaid has not been determined to be a bar to you being able to adjust your status. Okay. So if your child is 21, a US citizen, and qualifies to file for you, meaning she meets the income requirement, or you have someone else that meets the income requirement to sponsor you, then go ahead and file. Again, emergency Medicaid is not the same as regular Medicaid. So I live in the state of Massachusetts. We have something called Mass Health, which is what the Affordable Care Act was actually built off of. So in Massachusetts, we have Mass Health Standard, and then we have something called Mass Health Limited, which is emergency Medicaid, right? when we go to interviews and the officer asks my clients, do you have health insurance? And they say, yeah, I have mass health. I'm like, please be more specific on the type of mass health you have. Because if you're undocumented and you have mass health standard, that's a problem, right? Because you don't actually qualify for mass health standard. However, if you're undocumented but you get mass health limited, that is not a problem for adjustment of status. And I've had clients go through that, and we disclosed it to the officer, and the officer's like, oh, the emergency one. Okay, cool, moving on. Okay, so it's not always what you think is the problem. Um, okay. So, question. I was detained by ICE a couple of years ago and got my citizenship. Meanwhile, I was getting my case under my mother. I was detained in Oakville. People said I was lucky. Yeah, I'm telling people it's one of those things that, like, when it comes to citizenship, and when a child automatically a citizen because of the parents' citizenship, it makes me so happy, especially if there are things that could make that child deportable without that citizenship. Okay, so Top Shot was just saying they were in that situation where they were detained, but because they had the citizenship automatically through the parent, they were able to get their citizenship. Okay, and citizens cannot be deported unless you're a naturalized citizen and you go through denaturalization. But a citizen cannot be deported unless they have been denaturalized in the first place. Okay. All right. Okay. So I want to address this comment because it is so common that I want to make sure that we are all understanding how US immigration works. All right. So this comment says 30 years should have been got the documents. And that was a response to how to with Mika, where she was saying her mom has been here for 30 years and trying to get her green card now. Well, people assume just because you've been here for so long that there is a path to you then getting your documents. There's not always a path to you getting your documents, especially for someone maybe did not have a US citizen child, a US citizen spouse, a US citizen parent. Like, if you have all those things lined up, once you overstay your visa, your options dwindle. Like, when I tell you your options dwindle, they dwindle. You literally have family based, which is immediate relatives of US citizens, right? And then you have the humanitarian stuff. So asylum, U visa, T visa. But asylum requires you to have been persecuted or fear persecution based on a protected ground. U visa requires you to have been a victim of certain types of crime in the US and that you helped a law enforcement officer agency to investigate or prosecute the crime. And then the T visa requires you to have been a victim of trafficking. Someone can go through their 30 years in the US and not have met any of those things and not be able to legally change their status or legally adjust their status. So when we talk about someone being here for so long without status, I see this all the time. All the time. And it's not because they didn't want status. It's just because the options in the US for someone to gain status after they receive a visa or if they enter without inspection is very, very limited. Very, very limited. Okay. What are some questions asked at the marriage green card interview? Great question. I do have a whole video on this, so please go watch it. But they will ask you how you met your spouse. Like the first, so I just did 2 marriage-based interviews yesterday. So let's kind of break down how it worked. So The officer went through the forms, made sure all the information is up to date, and then said, now I'm going to ask you questions about your marriage. And the first thing they asked each of my spouses yesterday was, how did you meet your spouse? That was the first question they asked. How did you meet your spouse? Were you introduced by somebody? When did you start dating? How did you propose? Who proposed? What was your wedding like? Who attended your wedding? Right? All those relationship development questions, they're going to start with that because they want to know, do you know your spouse? Right? Do you know when you started dating? Do you have all those information? So that's where it's going to start. Then they're going to ask you questions about your day-to-day life. Like one of my couples, they asked, what car does your spouse drive? What car do you drive? What's your spouse's work schedule? Where do they work? How long have they worked? Right? Things that you should know about your spouse. Those are the type of questions you should be prepared to answer. One thing I will tell you is, in those relationship development questions, if there is any discrepancy between what one spouse says is how they met, how they propose, all those things, and what the other spouse says, that is going to lead to a tougher interview. I can tell you that much. And the more discrepancies you have, the more likely you are going to get referred to FDNS, which is the fraud division, or you're going to get a notice of intent to deny. So your interview is so important that for my clients, we do a whole mock interview, okay? I ask them questions, and if there's shakiness, I need to know what that is, right? Because before I take your case as my client, I have to believe your marriage is real. And if I'm doing a mock interview and I get red flags, as someone that already believes that marriage is real and I get red flags, that means the officer is going to get major red flags. So we want to address those things before we get to the interview and make sure that it's not because the marriage is not real, but maybe it's because you think your date when you went to Dunkin' Donuts and met for the first time, and your spouse thinks that the first date was when you went to a fancy dinner and all that stuff, right? If that's the discrepancy, we can fix that. That's not a problem. But if it's something more, if it's something deeper than that, then that's a whole other issue. But just know, I do have a couple videos on the channel on specifically marriage-based interviews because they are so important. Okay. Is government housing a bar? So having government housing can lead to you potentially have a public charge issue. Now, when people say government housing, I want to make sure it's clear it's a problem. So if you are undocumented, but you have children that are US citizens, and you apply for public housing based on the fact that you have children that are US citizens, and it's the children getting the housing, and you just want to be their guardian, right? It's the same thing with food stamps, or, actually, it's the same thing with food stamps. So if you are, you're the head of the household, but you have children that are US citizens, your children can still get food stamps, even though you do not qualify for it. So when people talk about whether it's a bar or not, it depends on who actually got the benefit. Is it the person that's undocumented, or is it their children? And if it's the children or their, documented spouse, then it's not a problem. Okay, because I have seen this. Okay, I have seen this happen where the US citizen spouse and the US citizen child were the ones that actually received the benefit and not the undocumented person. And in that situation, it was not a problem because they were honest in their applications and they made it clear that they themselves do not qualify, but their child that's a US citizen or their spouse that's a US citizen qualified for it. So don't automatically think, right? If someone is in government housing, do not automatically think that they are the ones receiving the benefit, okay? It could be their children receiving the benefit. And because they're their guardian, they get to live there too. Right? All right, Malik. My online status stuck on ready for interview, but I already interviewed almost 2 months ago. What do I do? You just wait. You can do a service request. You can contact your congressperson, but is it? It happens. I had one, like I said, had interviews. It's still stuck on scheduled for interview. Right? It's still stuck on schedule for an interview. But it's not you. I can tell you that much. They're going through some things. Okay, USCIS has been going through some things, and their officers are going through it. So patience, but service requests, congressperson's help are the two things that you can actually. Yes. Yes, derived citizenship. So if you come into the US and let's say you got your green card and your parent became a US citizen before you turned 18, you are automatically a US citizen through derived citizenship. That is how I got citizenship. So again, it's CRBAs and derived citizenships and 600s are my favorite things because again, I have a personal connection to it because that's how I got my citizenship was through that process. So yes, we are derived citizenship cousins. All right. Yes, Casmita, thank you for the always shouting it out. But yes, please do like the video, share the video. If you have questions, please put them in the comments. That's actually all I'm here to do today is answer your questions. So please make sure to put those in the comments so I can see them and respond to them. All right. So while I'm waiting for your questions, I am going to also answer other questions. All right. So if the parent, so for the CRBA, if the parent lives with child at border on Mexico's side, but works in the US side and has an address, pays taxes and everything, crosses the border every day to be with family, can they still file for this? Does not qualify for the CRBA because they have not lived in the US. So as long as, so I was giving people options for when they don't qualify for a CRBA, right? If you do not qualify for a CRBA, you may qualify for an N600K. If, and this is a big if you actually reside with your child outside of the US, right? Your child must be in your legal and physical custody, meaning that you live with that child outside of the US. CRBA says you don't have to live with the child as long as you meet the physical presence requirement and that you were a US citizen before the child was born. The child is automatically a citizen and you can file the CRBA. But if you have the physical presence requirement, but you do not live in the US, and you have no intentions of your child moving to the US, then the CRBA is not really a great option for you. You may want to consider an N600K. And another thing about an N600K, other than the fact that you don't have to like move back to the US or have your child move to the US with you, is that if you don't meet the physical presence requirement, but you have parents that meet the physical presence requirement that are US citizens, you can actually use the grandparents' physical presence to make up for the parents' lack of physical presence. It is one of those like legal miracles that happen sometimes. Not everyone fits into it, but sometimes you do. And if you do, you use it to your best. You just use it to get you where you need to be. Okay. So if the person is living on the Mexico side, residing there with their child, and 600K is most likely going to be their best bet, because that's going to allow the child to remain outside of the US. That's going to allow the parent to still live outside of the US, and not have to actually move their life to the US before they can give the child citizenship. So, like I said, it's legal and it can change people's lives. Okay. 601, want to make sure. All right. 601 and 212 with my, I guess, a new green card. Could I travel with no problem coming back with old crime in my record, but new green card holder? Well, if the crime was already waived, I'm guessing that's what 601 waiver is for. So typically, if the crime is already waived through a 601 waiver, it then doesn't trigger an inadmissibility issue, because the 601 waiver is to waive the inadmissibility issue of the crime. So typically in those situations, no, travel should not be a problem because you're a US citizen. However, again, not legal advice, but typically that crime is waived. And if the crime is waived, it's then not used against the person as a way to make them inadmissible to the US because it's already waived. All right. And remember, if you have questions, please, please, please go ahead and put them in the comments. All right. Next question. Can we do, you guys have a lot of questions on CRBA. Can we do any correction in CRBA application related to physical presence dates? I did not mention specific entry, exit in CRBA application, but I mentioned specific date in the 5507. I submitted the application online. Can I correct and add specific detail of exit and entry while in the CRBA interview through the consular officer? Yeah, so you can update the application with the officer. They prefer that you edit the application before the interview, especially if it's something that could affect the eligibility, especially that physical presence. Because it's an entry and exit date that you missed, if it makes you not eligible for the CRBA, that's going to potentially be a problem during the interview. So you want to make sure that it is not something that's going to make you not eligible for the CRBA. So let's say you forgot to put that you spent 2 days in Canada and came right back, but you have like 6 years of physical presence in the US before the child was born. That's not going to be a problem, okay? But if, let's say, you forgot to put that you were out of the US for a year, that's going to be a problem. Okay, so it just depends on how that affects your eligibility. If it doesn't affect the eligibility of the, of the child being able to get that CRBA, then I don't worry about it too much. The officer would want to know about it. Okay, the officer would want to know about it, but please, please, please don't stress about it if you're still within, right? You're still within the eligibility of the physical presence. You still have your 5 years, even with that exit and entry. Just tell the officer about it. Yeah, just tell the officer about it. All right, next question. Can my foreign girlfriend apply for a tourist visa, then get married online while she is in the Philippines before the USCIS interview, and then enter the US on a status after tourist stay time, because USCIS does not recognize online marriages. Whew, okay, that's a lot. So, one, can your foreign girlfriend apply for a tourist visa? Yes, if they qualify for a tourist visa, right? They have to meet the requirements of showing that they plan on leaving the US and they have ties to their home country that make it so that they have no intentions of remaining in the US. Now, getting married to a US citizen, whether online or not, before your USCIS interview, I'm guessing you mean embassy interview, could be a problem when it comes to showing that you have sufficient ties to your home country, because one, you have to disclose that you're married now, and two, marriage to a US citizen is one of the biggest red flags when it comes to a tourist visa. So if you are married to a US citizen, your chances of getting a tourist visa to the US is very slim, unless you can show a lot of ties, because the embassy knows. Like, we act like the embassy is not aware of what happens, but the embassy knows that spouses of US citizens that enter the US with a visa are able to eventually adjust their status in the US without having to leave the US because they're immediate relatives of a US citizen. The embassy knows this. So unless you can show them strong ties as the spouse of a US citizen, that you plan to go back and you have really great reasons for wanting to go back, the chances of you getting that tourist visa is very slim. And then if you have the intent, right? A tourist visa requires you to have non-immigrant intent, meaning you are just coming here for a visit to leave. You have no plans of staying here long term. Okay, zero plans of staying here long term. So if you already are getting married online and doing all of these things before you come into the US, it's going to be hard to fight the intention issue, right? It's going to be hard for you to say, oh, I never intended to stay in the US, but you already did, because you're already planning on how you're going to stay in the US. So you want to really be cognizant of that when you're making these decisions. And then your last statement about USCIS does not recognize online marriages is false. Okay, it is false. USCIS recognizes online marriages if it is legal in the state that it takes place in. So Utah, for example, has an online marriage. However, in order for it to be legal for USCIS purposes, you have to show that you consummated the marriage. Now, how do you show that? You show that you and your spouse were in the same space, and then USCIS can use their imaginations from there. But if you can't show that you consummated the marriage, or that you and your spouse were in the same location, and then let USCIS use their imagination of the consummation, the marriage is not real. It's not legal for USCIS purposes. It's just like if, so I'm Nigerian. We sometimes do proxy marriages where the spouse may, the wife may be in Nigeria, the husband is in the US, and the husband is not able to come back in time to do all the traditional marriage things. So they have a family member stand in for them. That's a proxy marriage because both spouses are not there for the marriage. So online marriages are proxy marriages. And the only way USCIS recognizes proxy marriages, the only way the embassy recognizes proxy marriages is if you can show that marriage was consummated. And the only real way to show that is to show that you and your spouse were in the same place at this time after that proxy marriage took place. Okay? If you cannot show that, then the proxy marriage is not legal yet until you can. So it's a whole steps to it, but just wanted to really address that part of the question. All right. I'm a US born citizen, never lived in the US. I have a 1-month-old daughter born in the UK and plan on moving to the US soon. What can I file for my daughter? Okay. So at this point, if you plan on moving back to the US, you need to take steps to show that you do plan, like you have legitimate plans of moving to the US, that you're already taking those steps. If you are taking those steps, then you would file an I-130 because unfortunately, you would not qualify for the CRBA if you never lived in the US. However, since you're living outside of the US with your child, you could do an 600K for the child, or you can do an I-130, and then once your child comes into the US, they would automatically become US citizen. So just depends on which option you want to do. However, there is the I-130 path, but that requires you to show US residency, whereas the N600K, you may be able to do N600K if you can show that your parents, if they are US citizens, that they meet the physical presence requirement, that they lived in the US for 5 years. And then you can use their physical presence to make up for your lack of physical presence and still be able to N600K, because that way you don't actually have to take steps to move to the US, because the N600K just requires you to be living with your child and have legal and physical custody of your child, which you're already living with your child outside of the US. You need the physical presence part of it, which you can borrow from your parents if they are US citizens and if they meet the physical presence requirement. But if that is not a possibility, then an I-130, and then consular processing, going to the embassy for an interview, and then after that, entering the US with their permanent residency. And when they enter the US with a permanent residency, they become a US citizen. Oh, yeah. So parents are British, not US citizens. In that case, the I-130 path would be the way to go. All right. So please, please ask me questions. I think, oh wow, I just looked at the time. I don't pay attention to the time when I'm like live. I just go until there's no questions and then we're out. But I just looked at the time like, oh wow. So it's only been like 30 minutes that we've been live, but apparently it's more than that. All right. I'm trying to see if there's another question here that I can answer before we get going. All right. I want to take this question because I just did a short on this specific thing. So if you are doing an international adoption, especially if it's not a big convention country, we need to talk, because some of you are just going to the country where the child lives and doing an adoption and thinking you can just file an I-130 for the child and bring them to the US, and that's not how it works at all. So this person is asking, I have finalized my adoption. Must I use a service of an adoption provider or just get the home study done? This question is going to depend on a couple things. All right. You need a home study if you are trying to say that the child is an orphan. In order for you to be qualified by USCIS to actually adopt a child and bring an adopted child to the US, you need a home study. Basically, is where someone comes into your home, asks you questions, make sure your home is suitable for a child to come into. And then with that, USCIS can move through your adoption process, okay? Super important. But do you need an adoption service provider? The adoption service providers are the ones that are going to do the home study. So all you need is a home study, but that home study needs to come from an adoption service provider in your state. Okay, not just anyone. Okay, just go to anyone to get your home study. It has to come from an adoption service provider. So I think sometimes people confuse the two, think that they are two separate things. No, the adoption service provider in a Hague Convention case is very involved in every single step of the process, not just the home study. But if you're doing an orphan adoption, if you already went through the adoption process, you still need that home study and you still need to go through an adoption service provider. It's a whole build up before you can then file for the child. One thing I did want to flag for people is if you are going through and adopting and going through the orphan process, please know that you have to file the petition. The orphan petition has to be filed before that child turns 16. Okay. I had to break this news to a potential client recently and did not feel good. Okay. It did not feel good because they missed that. Right? They thought just because they adopted the child, it's their child, they can go through the I-130 process, but you can only go through an I-130 process if the child does not live in a Hague Convention country and if they have lived for 2 years in your legal and physical custody. Not that you provide a place for them to live, not that you are the one paying all the bills, none of that. They are literally in your legal and physical custody, which means you have to live in the country where the child is for 2 years. And most people that are US citizens living in the US are not going to do that. I have people that have chosen to do that because they figured that would be the best way for them to bring their child to the US and they were willing to go through that process. However, I have seen that most people are not willing to do that. So if you're not willing to live with the child, do not file an I-130, file an orphan petition, make sure the child qualifies, make sure you're going through the right process because the orphan petition has a deadline. Adoption process has a deadline. If you adopt the child after they turn 16, it's over. Okay, unless you're also adopting one of their siblings that's under the age of 16 and the other child is not 18 yet. It's a very tight window that if you are not careful, you can end up not being able to bring your child to the US. So it is something I have seen in practice that I just don't want people to go through it because the adoption process in of itself is already difficult. Then you add the immigration part to it and it can really mess a whole family up. So what I typically advise people is before you start the adoption process, where the child lives, meet with an immigration attorney. Okay, meet with an immigration attorney, meet with an adoption service provider to make sure you have all, you know what you need to know about the process, whether it's with the immigration end of things or just the general adoption home study part of things before you start the process. Because again, you miss any of these steps, you miss any of the deadlines, you have a child. Yes, you adopted that child and they are your child, but you would not be able to file for them to come to the US. And it is so heartbreaking for me when I have to tell people that, right? When I have to be the one to say, oh, by the way, you missed all these deadlines. And yes, I know you thought you could just file an I-130, but you still can't because of these reasons. And again, heartbreaking and not a fun part of my job, but I have to do it. Okay. I have to do it. And I always like to tell people, I'm not always going to tell you what you want to hear. Right. When you come to me, I could charge you like all this money and then tell you at the end, oh, I guess it didn't work out. But no, that's not what I do here. And y'all know that. I tell you from the jump, this is not going to work, and these are the reasons it's not going to work. But there may be another option, there may be other things to consider. But if there's nothing else to consider, I'm also going to tell you that. So I always want my clients to be prepared and to know what to expect at every single stage, because the surprises that come with immigration, the changes that come with immigration, when they start caring about certain things over the other, you want to make sure that you are prepared for all of it. Okay? You want to make sure that you are prepared for all of it. All right. Last question of the day, in the comments, is, can a US citizen file for a step parent? And the answer to this is a big fat yes. Oh, you know what? I don't know. Okay, let's just go ahead and decline that call that just decided to come in right now. But yes, a US citizen can file for their step parent if the marriage between their biological parent and the step parent happened before they turned 18. And the reverse can be true as well. A US citizen step parent can file for their stepchild, again, as long as marriage took place before the child turned 18. If the marriage takes place after the child turns 18, just like the actual one, yes, they are your stepchild. However, for immigration purposes, they will not be recognized, and you would not be able to file immigration petitions for them. So that's why in the real world, regardless of the age of the child, if you adopt them, they're your child. But we always, again, immigration things, we always have to look at things from an immigration lens of, will this lead to a petition that can be approved because of, when it took place. So that is one of those things that does have an age deadline. If it was like they were 17 and you got married the day before their 18th birthday, they are your stepchild for immigration purposes. If you got married on their 18th birthday, they are not your stepchild for immigration purposes. So that's how strict these things are, okay? It's not whether you say, oh, well, they were almost 17. It was only a day after, or it was only the day they turned 18. It doesn't matter. Immigration is very strict about these things. And the more you know that, the more you're able to really process how all of this works. Hopefully, the more, well, not the more, the less heartbreaks we get moving forward in the world of family-based immigration. All right. So that is all I have for you today. Please let me know in the comments if you're watching this on the replay and you have questions. Please go ahead and ask me. And as always, if you're watching a video of mine and you have questions, put it in the comments. I do go back and respond. I'm taking next week off. Be my one Friday off this month. So I'm taking next week off. Ask me your questions. You will get your Tuesday video. I'm not going to leave you hanging on that one, but we're gonna have a Tuesday video, just no Friday video. I'll be back the week after that, and we can talk about all the policy changes, because after my last video and all the policy changes, there were more policy changes. So yeah, we're going to be talking about immigration policy and news and all of that in the video that will be coming out. No, in my video, live video for first week of July. August. Wow, July is almost over, guys. Sorry, now I'm just rambling. I'll see y'all later. Have a great rest of your day. And remember to like, share this video. If you're not already subscribed, please go ahead and subscribe. You get a bunch of immigration content. And as always, if you want to schedule a strategy session with me, it is a free 15-minute session. I also offer a 30-minute paid session as well. But you can find both of those on my website, lilylegal.com, and click on contact us. Thank you. I will be seeing you